Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 11 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between August 26th and September 2nd, 2020. We will start with a contracts case, Heart Care Consultants versus Albataineh. In this case, the court addresses the doctrine of res judicata and election of remedies. The underlying dispute began when the defendant, Albataineh, quit his job as an associate at Heart Care Consultants, the plaintiff, and opened up his own cardiac practice. As an employee of the plaintiff, the defendant had a non-compete agreement which restricted his own private practice. The plaintiff filed a suit claiming the defendant violated the agreement. The defendant filed a counterclaim alleging that he was owed back compensation. The two parties settled the matter and a formal settlement agreement was entered into. The agreement included liquidated damages in the event of a breach of contract. A third action was brought by plaintiff alleging that the defendant had violated the terms of the settlement agreement and plaintiff was seeking liquidated damages. After a non-jury trial, the judge found that defendant was in fact in violation of the agreement, but that the violation was de minimis and therefore the plaintiff was not entitled to liquidated damages. The plaintiffs then brought a fourth action claiming that the previous judge erred when finding that the plaintiffs were not entitled to liquidated damages. The judge in the fourth action found that the lawsuit was barred by res judicata and this appeal follows. The doctrine of res judicata says that a matter that has been previously litigated by a competent court may not again be litigated by the same parties. For res judicata to apply, the two actions must have identity of the thing being sued upon, identity of the cause of action, identity of the parties, and identity of the capacity of the parties. Here, the plaintiffs argue that res judicata does not apply because the cause of action is not the same. The court ruled, however, that identity of the cause of action does not require that the form and theory of liability be the same in the two actions. Rather, the critical issue is whether the plaintiff is suing to recover for the same acts and alleged wrong that were the subject of the prior action. The court found that all four elements were met and the fourth action was in fact barred by res judicata. The court also addressed the doctrine of election of remedies. The court held that even if res judicata did not apply, the election of remedies also barred the fourth action. Election of remedies states that once a party has made a binding election of damages as its remedy for breach of contract, it is barred from subsequently maintaining an action for the inconsistent remedy of rescission. While the pleading and attempting to prove the inconsistent remedies of damages and rescission is permitted in the same action, a binding election does occur when the litigation reaches a legal resolution, such as a settlement or a judgment, as happened in this case in the third action. We next address three criminal law cases. In Commonwealth v. Smith, the defendant was stopped pursuant to a traffic stop after the officer observed him traveling at a high rate of speed. Ultimately, the defendant was arrested for DUI. The defendant filed a motion to suppress, arguing that the officer did not have probable cause to stop his vehicle. The trial court denied his suppression motion, and he was convicted of traveling at unsafe speed and DUI at trial. The defendant appeals the order of the court denying his suppression motion. The Superior Court found that the officer did possess probable cause. Probable cause exists where the facts and circumstances within the officer's knowledge are sufficient to warrant a person of reasonable caution in the belief that an offense has been committed. In a determination of traveling at unsafe speed, the violation depends on the speed in relation to conditions and actual or potential hazards. In this case, the defendant was driving at excessive speed on a dark, windy, curvy, hilly road with lots of intersections and houses along the side. The Superior Court found that the estimated excessive speed in combination with the conditions of the road were sufficient to provide the officer with probable cause to stop the defendant. The order of the trial court is affirmed. Commonwealth v. Gaston addresses consent to a blood draw post-Birchfield. Birchfield v. North Dakota was the U.S. Supreme Court case that found that motorists cannot be deemed to have consented to a blood draw upon pain of committing a criminal offense. In Pennsylvania, prior to the Birchfield decision, a refusal resulted in increased criminal penalties, and drivers were advised of these penalties when being asked to provide a blood sample. In this case, the officer alleged that the driver agreed to submit to the blood test prior to being advised of the increased penalties. The defendant argued that he was advised of the criminal penalties by the officer prior to consenting. At the suppression hearing, the court found the testimony of the officer credible and the testimony of the defendant incredible and denied the motion to suppress. The Superior Court found no abuse of discretion and the defendant's consent to provide a blood sample was not due to the threat of increased criminal penalties. In Commonwealth v. Carmenates, the defendant was stopped when he was observed traveling too closely behind a truck. The trooper who stopped him was an expert in criminal interdiction. It was his primary duty to observe traffic and reduce the flow of interstate criminal activity. During the stop, the officer observed many things that led him to believe that the defendant was likely involved in criminal activity. The defendant only spoke Spanish and the trooper only spoke English. The trooper used Google Translate on his phone to communicate with the defendant. The trooper asked the defendant at one point if he could see the defendant's luggage. The defendant agreed and opened his luggage, and the trooper discovered marijuana and drug paraphernalia. The defendant filed a motion to suppress, claiming that the stop was illegal and that the consent was not voluntary. The trial court granted the defendant's motion to suppress on the grounds that the defendant's consent was not voluntary and that the Commonwealth appealed. The Superior Court reversed the ruling of the trial court, finding that the evidence did not support the conclusion that the defendant's consent was not voluntary. The evidence showed that the correspondence was cordial, and at no time did the defendant express that he did not understand what was going on. And while Google Translate is not always 100% accurate, the defendant was able to understand and respond appropriately. Most importantly, the court found that the defendant understood that the trooper wanted him to open his luggage when the trooper pointed at it, and he exhibited his consent by opening it without complaint. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. We'll finish up today with two property cases. Cantanzaro v. Pinnell is a property case addressing appellant's claim to quiet title over a parcel in Clairton, Pennsylvania. Pursuant to Pennsylvania Rules of Civil Procedure, a successful plaintiff in a quiet title action who is in possession of property may compel an adverse party to commence an action of ejectment. To prevail on the claim, the plaintiff must prove three elements: that she is in possession of the property, that the defendant is out of possession, and there is a dispute between the parties as to the title of the land in question. In this case, the appellant was able to establish that she was in possession of the property and that the appellee was out of possession. However, she failed to establish a dispute as to the title by failing to show that she had any countervailing ownership in the property. Appellant makes no claim to title, and that omission is fatal to her claim to quiet title. Therefore, the preliminary objections of appellee, which were granted by the trial court, are sustained and the case is dismissed with prejudice. The final case for the week is In Re Condemnation of Land in Bristol Township et al., the appeal of the Bank of New York Mellon et al. This condemnation proceeding involves the bank, who had an interest in the property, contesting whether they had a right to petition a board of viewers to evaluate the property when the property owner did not. When the declaration of taking was filed condemning the property, the owners of the property did not file preliminary objections, nor did they request a board of viewers. The bank, from whom the owners took out a mortgage, did not seek to intervene at that time. Later, a proposed distribution was filed, and again the owners did not respond. At this time, the bank filed a petition requesting a board of viewers. The eminent domain code allows only the condemnee, the owners in this case, the condemnor, or any persons displaced to petition for a board of viewers. The bank argued that they had an assignment in the mortgage giving them the same rights as the owners. The court found that the assignment provided only for an assignment of proceeds, not of actual rights, including the right to request a board of viewers. The bank argued that without the ability to petition for a board of viewers, they were without recourse. The Commonwealth Court found that while the bank was not permitted to petition for a board of viewers, they could have intervened in the condemnation proceeding when the original declaration was filed, but they did not. The failure to intervene, coupled with the improper assignment in the mortgage, did leave the bank without remedy. However, it is not for the court to provide an avenue of relief where the legislature has not, and where the bank did not take the appropriate steps to adequately protect its own interests. Thank you again for joining us in the Pennsylvania Case Law Update While You Drive podcast. Hope you have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.